Yeah. Yeah, I'm sure. There's only you, the small fish in the big pond, not. Yes. Completely. And, really, yeah. Exactly. Now know your place. Know your place. Stick to your lane. Yeah. Okay. Yeah. I've made a Siglova. No, you know, Siglova has big rules. I suppose the year. Yeah, Siglova down. Yeah. 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 I've met you once. Yeah. 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 Fast pace. Yeah. 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 You're going to take a while to get used to it. Yeah. Yeah, you can change them. Just lull them in the sense of security and then slowly you'll start making those suggestions. Yeah. You're saying more. Can you imagine? Yeah. No. But remember, some of those might move out before, the scene might change sooner than you think because some of those people might move out and go elsewhere too. Yeah. Yes. Yeah. Yeah. It is, yeah. Oh, yeah. Really good rule. How bizarre. Well, yeah, they all say that we've all got a double decker somewhere. Yeah. I think it's nice to catch up. It will hold in if we need different things. We will. Yeah. Perfect. And we will think of things and yeah, and yeah, we'll look at restarting with getting the mentorship thing going. But we will also, yeah, make sure that you don't have FOMO and we will bring you into anything. Thank you, and yours. I'll let you know what my doctor says. Yeah, I think so. Yeah, yeah, cool. I'll let you know what mine says. Then you can tell your having because he's got his fourth opinion. Exactly. Yeah. Shame. Cool. You too. Bye.
and refugee law. We are still waiting for a few participants to join, but I suggest that we start today's webinar, and it's really my privilege to welcome you all again to this important and timely webinar on the topic of the loss and deprivation of nationality. This is the third seminar in a series of judicial training workshops hosted by the International Association for Refugee and Migration Judges and the Judicial Institute for Africa based at the University of Cape Town. And a special thank you to the United Nations High Commissioner for Refugees for their financial support and technical assistance in the preparation and the hosting of the seminar series. So I think you'll agree with me that nationality and the right to nationality serves as a bedrock of our identity. It is the legal bond that connects us to our states, the countries we live in. This bond carries obviously with it rights, but also responsibilities and privileges, as well as duties. However, the circumstances under which this bond can be severed, whether by action of the individual or the state, raise profound questions that touch the very core of human rights and legal protections. And the loss of and deprivation of nationality can indeed lead to statelessness, and a status, or perhaps more accurately, a lack of status, that leaves individuals vulnerable on the fringes of society, often without access to important rights like education, healthcare, employment, or the right to freedom of movement. And these implications are far-reaching and can span generations. Our distinguished speakers today will delve into these issues, addressing the legal frameworks that govern the loss and deprivation of nationality, the international principles at stake, and the very real human stories behind the legal theories and statutes. I hope we will examine the balances that states and indeed judges need to strike between sovereignty in determining nationality rights and the principles of the international law designed to prevent statelessness and to protect human rights. So we will also discuss the challenges that judges and legal practitioners face in adjudicating cases of nationality deprivation, the implications of immigration and asylum law, and the international efforts then to reduce statelessness. So as we proceed with today's program, I encourage you all to engage with our speakers, to ask probing questions, and to consider the broader implications of our discussions. And this is important because I think it's a fairly new issue in many of our jurisdictions. And for that reason, I think it requires a bit of careful consideration, discussion, and I hope that you will all enjoy today's presentations. So thank you for your attention. Let me introduce you to our speakers today. We have four brilliant speakers. We'll start off with Ivy Njuguna. Ivy is a protection associate with the United Nations High Commissioner for Refugees based in Nairobi, Kenya. Ivy will start off today's proceedings with a presentation that will touch on the important work that the UNHCR is doing in protecting against statelessness, assisting states to adopt the necessary policy and legal framework to prevent statelessness. And it's really a pleasure to have you with us, Ivy. Following Ivy, we are welcoming back Dr. Bronwyn Manby, who is an expert in the field of statelessness and issues relating to nationality. In fact, she's based at the London School of Economics in London, And Bronwyn has written extensively on nationality and statelessness. In fact, her PhD thesis focused on citizenship and statelessness in Africa, the law and politics of belonging. She has also worked very closely with the UNHCR on its global campaign against statelessness, and has written many in-depth reports on different regions of our continent, and has advised the World Bank on the Identification of Development initiative. She is also regular a teacher at the London School of Economics MSc program in human rights, teaching international human rights law as part of the core course of the degree. Our third speaker today is may also be known to many of you, is Liesl Miller. Liesl Miller is a senior attorney based at the Centre for Child Law at the University of Pretoria here in South Africa. Liesl has extensive litigation experience in the field of refugee law and statelessness. Liesl has also written quite a lot on the topic, and I think it's she's also pursuing a doctoral study on the theme at the moment. Liesl was also previously the head of the statelessness program at Lawyers for Human Rights in South Africa, where she was involved in a number of important court cases that brought about reform in the nationality and immigration laws in South Africa in order to prevent statelessness. Liesl has also been a regular contributor to many submissions to various international and regional treaty bodies, including the UN Human Rights Council, the African Committee on the Rights and Welfare of the Child, and has also presented cases to these structures. Our last speaker, my apologies, is Thandeka Chauke. Thandeka is a human rights lawyer and a social justice advocate with a focus on statelessness, immigration justice, and refugee and migrant rights, as well as sexual and reproductive health rights. She currently holds the position of head of the statelessness program at Lawyers for Human Rights, where she is very much leading initiatives addressing statelessness and access to legal identity. Thandeka is also the administrator, the Southern African Nationality Network, which is a regional collaboration among civil society organizations dedicated to combating statelessness in Southern Africa. So maybe just a few logistical points. I would request that you all switch your microphones off, you mute your microphones during the presentations. But I also again want to invite you to join the discussion and feel free to make use of the chat facility. It's the logo. There's a little icon at the bottom of your screen. Please, if you have any questions or comments during the presentations, please feel free to make use of that. We will break for a short health break after Bronwyn's presentation. But before we start, before then, I would like to invite Ivy to lead us into the first presentation, after which we will also have some time for questions and comments. Over to you, Ivy.
Good morning, everyone. I'll be taking you through the I Belong campaign updates. Jakob, sorry, I'm facing some technical issues. I am not able to share my screen. It's disabled for me.
That's not a problem, Ivy. We will upload your presentation from our side. Joel, can I just ask, could you please upload it from your side? Joel, do you have Ivy's presentation? I can't hear you.
Oh, you know, I think she's, I
Sorry.
think panelists are, wait, actually, they haven't got a right to talk. Let me just quickly give her talking rights. There we go. Sorry, I'm trying to do it.
Thank you.
Okay, Jill, are you able to upload it?
Let me have a look. One sec. Do I have the presentation?
Yeah.
Are you able to see now?
There we go.
Oh,
I think is
we
that
can
is
see
that the
it
right
now.
one? Ivy, is that
Um,
your, that's your one, right?
Yeah, that's the one I'm presenting from.
Perfect. So then we
my
just go to slideshow and then we're good to
presented
go.
now. 1 second.
Yeah, slideshow, and then
Um,
so it's the one to at the top next to animations. You'll see slideshow.
Are you able to see my screen now properly?
Yeah, but you need to start it as a slideshow, Ivy. So if you go to at the top next to animations, it says slideshow.
1 second. Yes. From beginning. There you go. Can you see the presenter mode now?
It's still showing the other view. It's not
maybe
showing
you
the
can try.
slideshow view.
I can see it on my double screen. Maybe you can try it from your end. Let me stop sharing.
Can you know what? I could just stop sharing and start again. Sometimes the screen kind of freezes. So share now with it in that
In the
slideshow mode, and I think then it will work.
Is it better now?
Yeah, there you go. Sometimes it
Okay,
just
thank
freezes in
you.
between changes. All good.
Thank you. Okay, perfect. Good morning, everyone. My name is Njuguna, as Jakob has introduced me, working with UNHCR as a protection associate in the Statelessness unit at the Regional Bureau for East Horn and the Great Lakes of Africa. So today I'll be taking us through the I Belong campaign update, which I'm sure a number of you are familiar with. It is a campaign that was launched by UNHCR in 2014. And it is a 10-year campaign that was meant to hopefully bring an end to statelessness. So this is our overview. There we go. We'll go through the achievements since the launch of the I Belong campaign in 2014, the challenges that are preventing greater impact, and updates on the developments. So since it's the beginning of the webinar, I'll take us through some basic information. So where do stateless people live? At the end of 2022, UNHCR had estimated that there are about 4.4 million people worldwide who are either stateless or with undetermined nationality. And unfortunately, this was 2% more than was reported in the previous year of 2021. And as we can see, these are the countries that have reported the highest numbers of stateless people. We have Cote d'Ivoire with 931,000 and Bangladesh, Myanmar, so forth and so on. So when we look at these numbers, unfortunately, fewer than half of all the countries in the world submit any data on stateless people. And this includes countries with the most populations. And due to this, we do not think that the 4.4 million is a true representation of the extent of statelessness globally. It is estimated to be much higher. There are data gaps and limitations generally, and they include in the estimation of reported figures, lack of updates on figures from states, lack of demographic breakdown of data, and stateless people being left out of national surveys and administration systems. So in the continent, we have a few countries that regularly update their figures, that being Cote d'Ivoire, which reported 931,000, Kenya, which reported about 16,779. This was at the end of 2022, and that number should have decreased now with recent developments in the country. South Sudan also reported a figure of about 10,500, Rwanda 9,500, and after that, the rest of the countries that report are Burundi, Cabo Verde, and Egypt, with very minimal figures. So currently, the efforts in the continent on improving these figures, and so far, Rwanda and Kenya have been progressive and included questions on refugees and stateless people in their census. For Kenya, it was in 2019, and for Rwanda, 2022. And in 2023, Djibouti, Burundi, and Uganda have been planning census, and they have been intending to include questions on refugee and stateless people. Another country that is in discussions or in dialogue to include figures on refugees, returnees, and stateless people is Somalia, who will have their census in 2024. So,
Ivy,
yes?
Ivy, may I interrupt you just a second? Some of the participants cannot hear you properly. Do you have a headset on? Is it possible to maybe be a little bit closer to the microphone?
I have a headset on with the microphone. Is it better now? I'm trying to move it next to my mouth.
Yeah, I think let's just proceed. Thank you, Ivy.
Okay.
Sorry.
Let me know if at any moment it's not clear, and I can try and disconnect from the headsets.
Thank you.
All right. So since the launch of the I Belong campaign in 2014 to 2022, the number of people who had their nationality confirmed or their citizenship confirmed or acquired is as presented in this graph. And unfortunately, we consider the sharp decline in 2022. In 2022, as part of efforts to reduce the number of stateless people, around 32,400 people acquired citizenship or had their nationality confirmed in 32 nations, in 32 countries. So this is the lowest figure since the launch of the I Belong campaign in 2014. And in total, since 2014, we have more than 500,000 stateless people, around 517,500 individuals, including those of undetermined nationality, who've acquired citizenship. So despite this significant progress in some countries to resolve statelessness, as well as farmer commitments in other areas to address statelessness, overall progress in resolving major statelessness situations has been slow. And it's quite unfortunate to see this sharp decline as we try and eradicate statelessness. So in relation to UNHCR's work on statelessness and UNHCR's mandate, we operate on 4 pillars. So the first being identification, which obtains a picture of the situation of stateless persons and includes identification, mapping, gathering information on statelessness and its scope, causes, and consequences. The aim of identification is to promote increased understanding of the nature and scope of the problem of statelessness and identify stateless populations to understand reasons that led to statelessness. So identification here, when you talk about identification, it includes assessment of the scale of the problem. This is numbers, geographical spread, and a breakdown of the demographic, establishing a profile of the population affected, that is the demographic composition, hopefully disaggregated in sex and age, determining the causes of the obstacles to solutions to statelessness. This includes identifying gaps in legislation and administrative practices, uncovering any issues faced, and identifying all stakeholders. In relation to identification, I'd like to mention the IROS, which is the International Recommendation on Statelessness Statistics, which was adopted in 2023 and provides details on how to map and identify stateless persons and gives practical guidance. So we'll see the IROS recommendations featuring several through our presentation, but it's good to note that this is a new development and it offers practical guidelines to states and their statistical agencies. Next, we have the pillar prevention. So in contrast to UNHCR's international refugee protection mandate, a principal focus of the statelessness mandate is to prevent statelessness from occurring in the first place. This avoids considerable hardship for individuals generally at a small cost. And prevention of statelessness means addressing possible causes of future statelessness. It entails analyzing and addressing such issues and gaps in nationality legislation, state succession, and or arbitrary deprivation of nationality, which we are going to discuss today. So as we talk about prevention, we need to keep in mind that although apparent causes of statelessness are often legal and technical, discrimination is often a key factor. So the other pillar, the third pillar that we're going to look at is reduction, which revolves around resolving existing cases of statelessness and supporting legislative and procedural changes that enable stateless persons to acquire nationality. Sorry for that. My mouse is quite happy to move on. So we were talking about reduction, and we said it revolves around resolving existing cases. And when we look at reduction, major statelessness situations are often linked to failure to include specific minority groups in the body of citizens at the time of independence, noting the history of our continent. And these situations are generally of a protracted nature. So our focus has been on finding a definitive solution to protracted statelessness situations and developing strategies to resolve such protracted situations often requires sustained advocacy efforts coordinated with other actors. So once we go into the developments and achievements since the start of the I Belong campaign, we will see states that have achieved significant reductions. And so when we move to protection, despite efforts to prevent and reduce statelessness still occurs. And stateless persons must therefore be afforded protection until at such a time that the predicament can be resolved. And this is through acquisition of an effective nationality. So where possible, interventions to protect stateless persons should be undertaken within a broader strategy to prevent and reduce statelessness. And under this, we advocate for the enjoyment of basic human rights and promote the accession to the 1954 Convention. So now we'll look at the I Belong campaign, which is what we're discussing. So as I had said before, the I Belong campaign to end statelessness was launched in 2014 and had a 10-year span. And the goal was to bring to an end statelessness within 10 years by resolving existing major situations of statelessness, preventing new cases, and better identifying and protecting stateless populations. So we are in 2023, we're nearing the end, and unfortunately, as we all know, we've not achieved the goal of bringing an end to statelessness. And this year's anniversary heralds the final year of the I Belong campaign, and the theme for this year is Leave No One Behind: Access to Rights, Dignity, and Sustainable Development for Stateless Persons. So the rise in forced displacement and conflict and insecurity across the world highlights the importance of inclusion, justice, and human rights development, which stateless people, by virtue of their situation and lack of legal status, are often deprived of. So for states to fulfill their obligations and commitments under the 2030 Agenda for Sustainable Development, to leave no one behind, we need to address the situation of people without a nationality. So yesterday, I don't know if any of you were aware or managed to log in. We had the celebrations for this year for the I Belong campaign. And for the first time, the panel was fully formed of either currently stateless people or formerly stateless people. And it was quite an interesting discussion to hear the journeys that the former stateless people have gone through and the challenges that they faced, like from their lived realities in acquiring nationalities and how it's impacted them. And the most interesting part of this panel, it was mainly formed of youth from across the globe who have started initiatives in the countries to help their communities. So if you do not tune in, it's still available online. That was quite an interesting discussion to hear the lived reality. So in relation to the I Belong campaign, states have shown great commitment to support to end and prevent statelessness through the campaign, but unfortunately, millions still remain without a nationality, and there's more progress needed. So the I Belong campaign was founded on the guiding framework of the Global Action Plan to End Statelessness, which had 10 key actions for states to take. And here we are. We consider 10 actions on our screen, and they had a time span of 2014 to 2024. And this were meant to be guiding actions for states. So we can see action 1, resolve existing major situations, ensure that no child is born stateless, removing gender discrimination from nationality laws, and so forth. So next, we'll go into the progress that we have seen since the launch of the I Belong campaign. Since the launch of the I Belong campaign, there's been progress on work on statelessness, and for UNHCR, the I Belong campaign has repositioned our work on statelessness, increased awareness and visibility on the issue, as well as renewed commitment for states to prevent and respond to statelessness. In the last 9 years, we've achieved more than the preceding decade, and as we have mentioned, globally, there have been close to 500,000 stateless people who, or those with undetermined nationality who've acquired a nationality or had it confirmed. So in the progress that we've seen in the last 9 years, we have more states bound by statelessness convention. There has been a steady increase in accession to the 1954 and 1961 conventions in the past decade, thanks to continued advocacy at global, regional, and country level. And in the month of October, we had the Republic of Congo accede to both conventions at the later stage, which is great progress. And then we've also seen stronger legal frameworks in all regions. And the progress in this area has been particularly impressive, with many countries around the world bringing their legal framework in compliance with international standards on the right to nationality and protection of stateless persons. So we've had 3 countries remove gender discrimination from their nationality law. That is Sierra Leone, Madagascar, and Nigeria, which has been great. And we've also seen solving of situations of statelessness, either fully or partially. And while the progress in this area has not been to the level that we would hope for, there still has been significant progress with certain countries and resolving situations. Forgive me for my pronunciation of this country's name. Kyrgyzstan has eradicated statelessness entirely. And then on the continent, we've also seen Kenya, which has granted nationality to several minority communities and is on track to address the situation of the remaining communities. So this year they had the recognition of the Pemba community, but in the past we've seen recognition of the Shona, Makonde, and some persons of Burmese descent. Globally, we've also seen progress in Vietnam, which has addressed statelessness among former Cambodian refugees, Turkmenistan, which addressed protected situations of thousands of the former USSR. So those are some of the countries that we've seen with significant reduction. And then we've also had greater visibility and increased stakeholder mobilization. At the global level, there is a group of friends of the I Belong campaign, which is based in Geneva and is made up of the permanent missions. They've been instrumental in delivering statements at EXCOM and the Standing Committee, as well as liaising with capitals and advocating on the issue of statelessness. So I think currently there are about 30 states who are in the group of friends of the I Belong campaign. Also, we've seen 21 countries adopt national action plans, which detail steps to be taken to advance efforts on eradicating statelessness. And we've also seen regional networks formed across the globe. And on the continent, we have the East Africa Nationality Network, which was established in 2022, as well as the South Africa Nationality Network, which are instrumental in advocating and strengthening the voice and visibility of stateless people. We've also seen thematic coalitions with other UN agencies and civil society organizations. And for this, we have thematic coalitions that have been established, such as the Global Campaign for Equal Nationality Rights, with whom events have been held, focusing on gender discrimination in national law. So this is a highlight of the progress that we've seen since the launch of the I Belong campaign, but we'll go further and look at notable recent legal reforms. We have Liberia, as we mentioned, that removed gender discrimination, a provision of that had gender discrimination preventing women from conferring nationality to their children on an equal basis as men in 2022. We also saw Rwanda have a change in legislation with the Organic Law of 2021, which introduced a new provision for acquisition of nationality on grounds of statelessness. Aside from the condition of statelessness, the only condition is that the person not be a threat to national security, which is something that we continuously talk about, lowering the requirements for stateless people to acquire the citizenship. And Rwanda promulgated in the Gazette a new nationality law, repealing and replacing the previous organic nationality law governing the nationality. And the law provides stateless people with facilitated naturalization to citizenship and fulfills one of Rwanda's pledges at the 2019 high-level settlement on statelessness, which we'll look at shortly. So key achievements within the last 1 year, since the last celebration and the last anniversary of the I Belong campaign, on resolving statelessness in July 2023, in Kenya, the president signed a proclamation confirming and recognizing approximately 7,000 individuals from the Pemba community as Kenyan citizens, and they were issued with nationality documents. And also in Tanzania, recently in September, the government naturalized over 3,300 long-term migrants from Burundi, Comoros, Mozambique, and Rwanda in the Zanzibar Islands. So that's great progress on resolving statelessness. We've also seen progress on accession to conventions. As we mentioned, the Republic of Congo in October acceded to the 1954 convention as well as the 1961 convention. So this is the key highlights within the last 1 year for our continents. Globally, we have more achievements in Kyrgyzstan, where an amendment to the nationality law came in effect in February 2023 and provides guarantees that children born in the country are considered citizens where they would otherwise be stateless. In Moldova, previously, for Moldova, the parliament adopted an amendment to the nationality law providing for access to nationality to children born in the country to foreign parents who are unable to acquire nationality of either of their parents. So previously, one of the parents had to either be a legal resident or officially recognized as stateless by the authorities. So this amendment eliminated these requirements. Protecting stateless people, we saw improvements in or changes in Portugal, which approved an act in June regulating the acquisition and loss of statelessness, status, which the act includes the definition of a stateless person in accordance with the 1954 convention and defines the contours of an SDP statelessness determination procedure to be established within 90 days following the adoption, which was in June 2023. On birth registration, in North Macedonia, the parliament adopted amendments to the law on civil registry in June 2023, guaranteeing birth registration for all children born within the country, regardless of whether their parents are undocumented or stated. So through this, you can see at least achievements based on the guidelines that were provided by the Global Action Plan to End Statelessness. So moving on from key achievements, part of the work that has been done involved the 2019 high-level segment on statelessness, which was organized at the midpoint of the I Belong campaign and was an opportunity for states to highlight achievements made from the beginning of the campaign, and it was also an opportunity to make pledges and also just share progress on the implementation before the second half begins. So it was an intergovernmental meeting of member states and other stakeholders, providing an opportunity for states to highlight their achievements, and a total of 360 pledges were made. The summary on the pledges can be found in the link below, but it is worth noting there are more pledges than what was made in the HLS. More pledges were made during the Global Refugee Forum, and here we have an overview of the pledges on statelessness. We had pledges made by states, international stroke regional organizations, and civil society organizations. These pledges have played quite a key role in seeing the achievement of the advancements we've made, because the advancements we've made are the commitments of states made during the GRF. So the thematic areas of the pledges were analyzed, and they fall as below. As you can see, 21% of the pledges were around ensuring birth registration for prevention of statelessness, 22% granting protection status to stateless migrants and facilitation of their naturalization. And the other one was improving quantitative and qualitative data on stateless population. So here you can see a breakdown. I hope it's clear enough on your screen. So those are the pledges made at both HLS and the GRF combined. Next, we're looking at the challenges preventing greater impacts that we've noted since the beginning of the I Belong campaign in 2014. So we have a gap between pledges and action. So states have expressed political will through their pledges, but impactful action through implementation has been slow and limited in many countries. This may be due to resource limitations, shifting domestic priorities. As we know, on the continent, we've had so many emergencies and situations which have changed what the priorities of states are. And in many instances, the political commitment has not translated fully into actions that show progress and follow up. But as we have said, this may be due to so many situations, so many reasons. And then one of the challenges is slow progress on solutions. And when we look at this, we look at major situations of statelessness that is different. So the granting of citizenship to stateless persons is a definitive and far-reaching solution. And while there's been progress in solving situations of many stateless populations, such as in countries such as Kyrgyzstan, which is resolved their situations, and Kenya and the other countries, some of the largest situations of stateless people have remained stagnant and seen limited progress in actual granting of nationality and documentation. And this has been despite the political will expressed by governments. And then additionally, we have statelessness being perceived mainly as a UNHCR issue, which I think was a main challenge at the beginning of the campaign, but as we've seen through like recent achievements, this has improved. And initially, there was limited ownership by other actors, especially development actors, where statelessness was seen as a humanitarian issue. But for example, the theme for the I Belong campaign in 2023 and 2024 is statelessness and development, and we'll look at it briefly later on. So another key issue has been statelessness being viewed as a complex legal issue, like creating a missed opportunity to see statelessness as a human rights issue and development issue, which would bring more actors into the game. The next challenge we have experienced is lack of data, and as we have said before, so far we have an estimated number of a reported number of 4.4 million, which for sure is not the accurate number, and the number is higher due to the limited reporting in the annual statistics. And also additionally, in relation to data, we have very limited socioeconomic data available in relation to statelessness, and with the exception of a study done on the Shona in Kenya, I think in 2019, as well as information on the Akkar region in Lebanon. So these are the key challenges that we are highlighting. And then next we have a shift we need to see to address the bottleneck and accelerate progress. So in relation to this, we hope for a shift from bilateral to multi-stakeholder engagement. And here we're talking about the Global Alliance, which I'll talk about a bit more in depth in the coming slides. But the Global Alliance is a multi-stakeholder platform that includes states, academia, civil society, organizations, faith leaders, and so forth. And one second. And I think I'll go through into that on it. The next shift we need to see is reposition of statelessness as a central SDG issue, mobilizing others in the efforts of our common agenda. And this shift is needed at national and global level to consider plans. And at global level, continued effort to include statelessness in our partnerships with development agencies. Further, we need to see a shift from general awareness raising to targeted influencing for specific high impact outcomes. So as we saw before, we have had general awareness raising, which has led to developments such as the Friends of the I Belong campaign and so forth. But in the future, there's hope to have it as specific targeted influencing and also still at a multi-stakeholder level. The I Belong campaign has played an important role in raising awareness on statelessness. And there is more knowledge on what statelessness means and why it is a concern. However, we need to move to key actions to end statelessness. This involves identifying and engaging influential stakeholders and advocates who can support policy change. There has been a push for systematic representation in global and national. There is a push for systematic representation in global and national population data through IROS. This is the UN Statistical Commission endorsed the recommendations in March 2023, and this offers an opportunity for national statistical offices to include stateless people in the national census and other surveys, and it will ensure better data on statelessness for guided actions and more targeted actions. And then last, we have strengthened engagement with stateless people and their voices, and ensuring their voices are better heard. As I have mentioned, yesterday we had the first panel comprising of fully either formerly stateless people or currently stateless people for the I Belong campaign anniversary. And for this, effective action against statelessness requires giving a voice to those affected and engaging them in advocacy at global level, national level, to institutionalize the engagement with stateless persons through their participation. We are looking at participation in the Global Alliance, which we highlighted, that we'll mention further. And also we have had the establishment of the UNHCR Statelessness Community Consultation Group, which is similar to the Refugee Advisory Board. So as we see the end of the I Belong campaign and post the I Belong campaign, we have some priorities and we've identified actions. So amongst them, in 2023, we have the Global Refugee Forum, which offers an opportunity for states and other entities to make pledges. And in relation to this, we have developed a guiding document for development of statelessness specific pledges that is available on our website, and we can share. And in the document, we have suggested thematic priorities in the pledge formulation. I won't go into each and every one of them, as you can see, my 30 minutes winding up. But we have the document which offers the guidance. Then further to that, we have the more actors and having it as a multifunctional issue. So here we want to have a closer link with development initiatives such as the 2030 Sustainable Development Agenda, as well as forging stronger partnerships with development actors at national, regional, and global level, and improving data on stateless populations, including the socioeconomic impact of statelessness. And as we mentioned, there's very limited. Next, we will be looking at the launch of the Global Alliance to End Statelessness. So the Global Alliance to End Statelessness is a project that will be launched in 2024. The vision of the Alliance is a world free from statelessness so that everyone enjoys the right to a nationality without discrimination. This is the logo. And as compared to the I Belong campaign, for the Global Alliance, it is not time-bound. However, the initial phase will be aligned to the Sustainable Development Agenda for 2030. But the Alliance is totally not time-bound, and the Alliance is part of the focus area plan on redoubling efforts on statelessness. So these are key activities that have been identified for onwards. So as we say, so restating, and the website will be live in 2023. It's a multi-stakeholder coalition with a vision of a world class statelessness, as we've mentioned. And the rationale is that this will be based off the momentum of the I Belong campaign, and it is also based off the identified need for multi-stakeholder collective action. So for this, the timeframe will be 2024 to those, including state-led organizations, governments, regional organizations, UN agencies, and other actors to facilitate collaborative action to end statelessness, capacitate its members by providing a platform to collaborate, as well as exchange information and learning, and catalyze and accelerate change by identifying and responding to gaps in laws, policies, and practice, building on the commitments by states and the need to eradicate statelessness. So membership, it's states, intergovernmental organizations, CSOs, stateless-led organization, UN agencies, and for this membership is limited, excluding individual membership. So you cannot join as an individual. Activities will be around the Social Solution Seekers Program, which is based off of champion states who have made significant progress or significant pledges in the eradication of statelessness, regional network labs, online marketplaces, which will seek to connect different actors, knowledge hubs, and thematic working with multi-stakeholder inclusive. And the global alliance is expected to achieve the following: change in the reduction and prevention of statelessness globally, strong, effective, and interconnected regional networks at the intergovernmental and civil society levels to support regionally contextualized solutions to statelessness. In relation to this, we saw quite a number of pledges from intergovernmental bodies to be implemented regionally. Shared ownership of statelessness as a cross-mandate issue amongst relevant UN agencies. Elevation of statelessness is a critical but solvable issue on the global human rights and humanitarian agendas. And promote deeper financial investment into collaborative efforts to address statelessness, strengthen engagement with state-led organizations as agents of change, and enhanced awareness and understanding of the issue by a wider range of stakeholders. So this is what the Global Alliance hopes to achieve in its overview. Thank you for your time and for listening to me.
Thank you, Ivy. And I think what your presentation points out is the pervasiveness of statelessness as an issue that is a problem not only in our region, but indeed globally. And that to tackle this problem, it really requires the participation of all role players in society. And as your presentation points out, that the UNHCR in its engagement with governments have made some progress to bring about the necessary law reform, as well as the reform in state practices to prevent statelessness, to protect those at risk of statelessness. And in doing so, I think it is important to mention that the courts have an important role to play in giving access to justice for people who are at risk or who have problems with regard to statelessness. So unfortunately, we are running slightly behind time. So I'm going to ask our next speaker, Bronwyn, to do her presentation, and so that if there are any questions or comments to Ivy's presentation, feel free also to mention it in the chat box, so that we can have a conversation and a question session after Bronwyn's presentation. Bronwyn, welcome back. I have introduced you in your absence. We are very privileged to have you back as a presenter, and we are very much looking forward to your presentation. Thank you.
Thanks very much, Jakob. Just to check that you can hear me.
Yes, we can.
The Zoom is telling me that I can't start my video because you have stopped it, so I think you need to give me permission.
Oh.
And also, can you see my screen?
We can see your screen, yes.
Excellent, very good.
Jill, can you just see if you can give her the video authorization?
I can try, but I think Vanya has the access to that. Let me have a look and see if I can.
I tried to do it and it just says you don't have
okay, let me, because it's telling me that you should have full panelist whatever you know, permissions. One panelist
yeah, you cannot start your video because the host has stopped it, it says.
Oh, well, I promise you I haven't.
Okay, shall I just continue with audio in that case?
Yeah, so just, start with that, and then I will try figure out in the background to sort it out.
Okay, Very good. Thanks, everybody. It's a pleasure to be here. I am going to give you a quick run through some comparative law in relation to citizenship in Africa. And first of all, I'm going to talk a little bit about the causes of statelessness in Africa specifically, although the causes are very similar globally. Then I'm going to talk about the some comparative law. And finally, I shall talk what comparative law and comparative practice, and finally a little bit about what just a slide or two on what the international standards are and the role of judges as well. So, what is statelessness? We have a definition, which I'm sure you already have. A stateless person is a person who is not considered as a national by any state under the operation of its law. And this definition comes from Article 1 of the 1954 Convention relating to the status of stateless persons. And it is apparently reasonably simple, but has in fact been very difficult to interpret, to come to a consensus on what it means in practice. And indeed, there's a kind of 20-page document, the Guidelines on Statelessness #1, which are now incorporated into the Handbook on Protection of Stateless Persons by UNHCR. So 20 pages on, what do we mean by person? What do we mean by considered as? What is the operation of its law? Long detail. Anyway, the sort of key phrase that I always pull out of it is that statelessness is a mixed question of fact and law. So therefore, to find out if somebody is stateless, you have to look at what is the law and how is it applied in practice. You can't only stop with the nationality law itself. So we have problem laws and we have problem procedures that create statelessness. Let's go through a quick run through the types of problem laws that may exist. And just highlighting in the African context and given the history of Africa, one of the main places where statelessness has been created, legally speaking, is in relation to the rules on state succession. That is to say, the rules that applied on the transfer of sovereignty between the colonial powers and African states, and who was automatically included, who was not included, what types of procedures had to be go through, was there a gap between the state succession and the adoption of the nationality law, which leaves a lack of clarity. So the rules on state succession and who had access to nationality at the time of creation of the state or of sovereignty of the state are a key cause of statelessness in Africa, but in many other regions of the world as well. Sex discrimination in law, transmission to spouses, but much more importantly, transmission to children. What are the rules? Do men and women have equal rights? And what are the rules applied in case of birth out of wedlock in particular, which is often the more complicated zone? Discrimination in law based on race, ethnicity, religion, other similar criteria as well. There are not many countries that have that explicitly in their law, but there are around 10 or so in Africa, which state that you have to be a member of an ethnic group established on the territory, or there's a list of groups, or you have to be a member of an indigenous community. The language changes, but there are a number of countries that have that, including most famously, of course, Liberia and Sierra Leone, where you need to be a Negro or Negro African, deriving obviously from the history of those two countries. An important cause of statelessness is the lack of the minimum protections against statelessness for children born in the country. So, and the 1961 Convention applies, but also the African Charter on the rights and welfare of the child, that if you are born in the country and you cannot acquire nationality from your parents, then you should have nationality of the state in which you were born. More generally, however, the fact that you have to prove statelessness to benefit from that right makes that it's always, even if it is in place, quite difficult to access. And so actually a more general set of rights based on birth in the country, for example, for the second generation born in the country, or if you're born in the country and resident until you become an adult. Those types of protections are also very important in terms of avoiding statelessness. Lack of a provision for foundlings, that is to say, children of unknown parents, lack of provision for adopted children, and also for other forms of care short of full legal adoption. Naturalization conditions, very difficult to access. Naturalization is very rare in most African states, in fact, in all African states now, just a few hundred people a year. And in particular, the requirement to prove legal residence and obviously, and often an existing nationality as well, which means that statelessness is created because you can't prove either an existing nationality or therefore legal residence. And we also have restrictions on transmission if born abroad as a cause of statelessness, because the country of residence assumes you have the other nationality, but you may not do so. Problem procedures, on the other hand, we have fundamentally the lack of access to birth registration. On average, across the continent, around 50% of children's births are not registered. That varies hugely, of course. I mean, some countries have almost 100% and some have 5%, but on average around 50%. But civil registration more generally is also very important, including marriage registration, adoption registration, death registration. All of these types of registration can be important. And in particular, they relate, birth registration in particular can be important in proving the connection to the parent on the basis of which nationality is acquired. If the parent's nationality cannot be proved, what are the assumptions made about the nationality of the child? That can create statelessness as well. Discrimination in practice based on sex, discrimination in practice based on race, ethnicity, and religion, and so forth, even if it's not there in the law. The lack of child protection systems, even if there is a founding provision. Is there a system to make sure that a child whose parents are not known is registered in the civil registration system and granted nationality in practice and the documents to prove it? Lack of access to consular assistance for people outside their country of origin is really important, and costs, of course, both official fees, but perhaps more importantly, unofficial fees. Around every office where people are applying for nationality papers, you will see a set of unofficial helpers who will offer to assist people through the route and charge a fee to do so. And it's not necessarily the help that they are providing is not necessarily wrong, but nonetheless, you have to pay a fee for it. And also just to highlight, one of the causes of statelessness is just history and a set of maps of Africa, which none of you will need to be reminded of, but the history of Africa creates particular challenges around who belongs in which country and how we think about that. I do want to highlight, however, that Africa is not unique in this regards. Similar problems around transfer of sovereignty exist in the former Soviet Union, in Asia, and even in the Americas as well. But nonetheless, there are particular challenges in Africa. So given these problem laws, problem procedures, and the challenge of history, which are the groups at risks of statelessness in Africa? The first group to highlight is not long-term migrants. I'm talking here people who've been in a country for 20, 30 years, but especially their descendants born in the country. So as a family, they've been outside a country of origin for so long that they have lost connections, practically speaking, with that country. No family known of, nobody who could testify to their origins and so forth. And in particular, we're talking about there's a large population of people who are pre-independence migrants, including those who are brought as coerced labor by the colonial powers, dumped in the country where they now live and have never been fully recognized as nationals of that country. And there are pockets of that type of person all over the continent, including in some of the countries that have faced serious conflict over who belongs, for example, Cote d'Ivoire or DRC, where the question of what is the status of pre-independence migrants has been central. Long-term refugees are also in this category, including their children born in the country, most importantly, and especially former refugees. So people who come from countries where has been declared that the country is now safe to return to, so they no longer have refugee status, which gives them an ability to operate, but they don't have any identity documents that are valid. But they also find out that they are not actually recognized. They can't return home, or indeed they have the concerns about returning home, or just their life is established where they are, but they can't acquire the nationality of the country of residence. Even long-term internal migrants, especially in the very large countries such as Nigeria or Congo, who are not living in the territory where their original community, as assumed from their family name or cultural origins, and can't prove where they come from. or they've got parents from two different ethnic groups, but neither will fully admit that they are a member of that group. And in the context of expulsions, or people who have been living long-term in a country and then there's conflict, and so they return, quote unquote, to a country of origin from maybe 2 generations back, but they find that they can't prove their connection to that country. We also have cross-border cross-border populations, groups divided by international borders, nomads and pastoralists, of whom there are many thousands in Africa, especially in west across the Sahel, west to East Africa, and who every country says, oh no, but you belong to the other one. Border disputes and changes. The transfer of territory for the Bakassi Peninsula between Nigeria and Cameroon has created a population whose nationality is very much contested, and new states. So new succession of states, especially Ethiopia, Eritrea, and Sudan, South Sudan, have created challenges as well. And generally, we have vulnerable children who, of course, don't remain children. They become adults. Somebody might be, 40 now and face challenges, but you have to think that at a time they were a vulnerable child. Simply, they had a foreign father in the context of sex discrimination. They were born out of wedlock. They were abandoned. They were orphans. They were trafficked. They were into forced marriage. All of these categories of children who don't belong to a solid family, who can, with parents who can take care of them and ensure that their status is recognized and that the legal questions are sorted out, are at risk of statelessness. And just to kind of highlight that it's very often the case that those who might be dual nationals are also those who are most likely to be stateless. This is kind of a paradox, because you think, well, if you're entitled to dual nationality, all the better, you're not stateless. But the difference here is that rich people are likely to be dual nationals in this context because they can fill out all the paperwork, they've got the education and the connections and the access to documents that means that they can get recognition of nationality. And poor people who don't have birth registration, who don't have connections, who don't have family members, are most likely to be stateless. And so to think about that is that the people at most risk of statelessness are those who have a connection to more than one country. Okay, so I'm going to take you on a very quick run through comparative law on nationality in African states. 2 slides to start off with on terminology. First talk about nationality and citizenship. So they are used interchangeably in English in international law. So while nationality is the term more often and is the term that I have been using in international law, sometimes citizenship is used and they have the same meaning. In the common law countries, English language dominant, citizenship is the term more usually used in the national law. So you have a Citizenship Act. In the civil law countries, so French, Portuguese, nationality is used at national level as well. So you'd have a Code de la Nationalité, for example, in French. But the Code de la Nationalité in French is the same thing as the Citizenship Act. We're not talking about a different set of principles. And also in Arabic, the word jinsiya is used, which means nationality rather than muwatana, so which is the cognate of citizenship. But just overall, citizenship and nationality mean the same thing in international law or in law in this context, although in non-legal usage, they are sometimes used in different ways. And another set of terminology around loss and deprivation, because that is what I'm about to talk about. And I'm going to use these terms as they are used in the 1961 Convention on the Reduction of Statelessness. And so here, loss, perte in French, means automatic withdrawal by operation of law, whereas deprivation, privation in French, means that the competent authorities have to take a decision. So it's not automatic. Again, at national level, the terminology may vary, but I'm going to be using the terms in this way as they are used in the 61 Convention. So let's look at loss of nationality. So automatic loss of nationality is most common, as you would expect, in case of dual nationality. So although the trend is very strongly to permit dual nationality, we still have 11 countries that provide for automatic loss of nationality if a person acquires another nationality. There are another 3 countries that provide that. So if a person is naturalized, but then they acquire another nationality, so a third nationality, they would, or maybe they've given up their first nationality, but if they acquire another naturalized nationality, then they lose their first naturalized nationality. And there are another 4 that require permission, including South Africa. But there is a recent Supreme Court decision which has said that that is not constitutional. The law has not yet been changed. There are also 6 states that say if you are born with 2 nationalities and retain the second nationality as an adult, you will lose nationality automatically. So the difference here is in one case, you are born with 1 nationality, but you go to another country and acquire its nationality. But there are 6 states that say if you are born with 2 nationalities, so you had no choice about the matter, but you have to give one of them up when you reach adulthood. And there are another 11 states where if you were given nationality on the grounds that you were a foundling because your parents were not known, but then later your parents are traced and another nationality is established, you will automatically lose the nationality of the country of origin. This can be especially problematic if that happens very late, but that's the provision that automatic loss in that case. There are other provisions on loss of nationality in relation to service in the foreign military. Residence abroad, if you've acquired citizenship by naturalization and you go and live in another country, you are at risk of losing your nationality. There's automatic loss in case of disloyalty, but only for naturalized citizens. In a couple of the Portuguese countries, we have automatic loss in case of fraud in a couple in Angola and Burkina Faso, and a particularly problematic provision in 3 countries, Liberia, Sudan, and Somalia, where if either your parents or in the case of Somalia, your husband is deprived, the children or the wife automatically lose nationality without any separate decision in their case. Much more common, however, one extra slide as well. So this is not exactly loss of nationality, but it's the loss of the thread of nationality from parent to child. And just want to highlight the question about transmission of nationality abroad. So we have 6 countries where the second generation born abroad does not acquire nationality. So you are born in Tanzania, you have a child born outside of Tanzania, that child is Tanzanian, but if that child has a child also born outside of Tanzania, the second generation is not Tanzanian. These are all, as you see, former British territories, and this rule applies in Britain as well up until today. We also have a much more numerous set of countries where even though nationality can in principle be acquired for children born in another country, you have to go through some form of procedure, usually registration with the consulate, sometimes registration in the country of origin. And we have 18 countries in this category. And of course, people have no idea that this is required. And yet, when they then go back or seek to acquire recognition of their country of parents' origin, they find out that the procedure was not completed. Very often it needs to be done before you become an adult, in which case you are not a national. So moving on to deprivation, which is a more common provision, and aside from the context of dual nationality. So around half of African states don't allow for a person born with nationality either to lose it automatically or to be deprived of it. Some of them deprive for deprivation in the context of dual nationality rather than automatic loss. So if you acquire or retain another nationality, the authorities can take nationality away from you. There are another few countries where you can be deprived of nationality if you are a naturalized citizen who resides abroad. It's not automatic, but it can be taken away from you. Almost all African countries, and indeed almost all countries in the world, provide for deprivation of nationality of a naturalized person under circumstances related to disloyalty or fraud. Sometimes these are relatively unproblematic in the sense that they respect the minimum standards set in the 1961 Convention on the Reduction of Statelessness, but sometimes they are extremely broad. So, for example, in Egypt, you can be deprived of nationality if you are alleged to be a Zionist. So it's not even convicted of any type of crime. It's just you might have expressed some point of view, and you can be deprived of nationality on that basis. There are only 8 countries that explicitly prohibit deprivation if a person becomes stateless. In practice, however, deprivation provisions are not often used. they are deployed sometimes, but mostly formal deprivation is not so often used, and it's really about the denial of nationality, the assertion that you've never had nationality to start off with, that is more important, and I'll come to that just now as we look at comparative procedures. So, first of all, just to highlight how important the administrative systems are in the context of deciding if a person is stateless or not, and that the substantive nationality law, that is to say the Citizenship Act, is really not the only law that is relevant. In order to decide if somebody is a citizen of a particular country, is a national of a particular country, you may need to look at civil registration. In fact, you almost certainly will need to look at civil registration, and not just birth registration, but registration of other civil status events. You might need to consider what the status is of a customary marriage, where some countries recognize customary marriages and others state that it has to be formally registered for the marriage to count as a marriage, and therefore perhaps for the child to acquire citizenship. You have to look at the status of civil registration documents issued in another country. So a country, a birth certificate issued by Nigeria is not valid in Côte d'Ivoire unless it is formally transcribed into Côte d'Ivoire according to procedures set out in law. And so if in order to be recognized as the child of an Ivorian parent, you're going to have to go through that process for that to take place. You need to look at family law, especially legal recognition of parentage in case of birth out of wedlock. You need to look at the requirements to be issued a national identity card or a passport, and if the person has can prove the elements required. You need to look at immigration law and what it takes to prove legal residence, which might be relevant both for naturalization but also for acquisition of nationality by the child. And you need to look at the laws on evidence, including the burden and standard of proof. So who has to prove, is it the state or the individual person, who has to prove that the person is or is not a citizen, and according to what standard of proof? And for example, if the person has previously been issued an identity document, and the official is now saying, I think you got that fraudulently, who has to prove that it was issued fraudulently? Does the person have to prove that they got it correctly, or does the state have to prove that it was issued fraudulently? And in that can often be a question in issue. The African Court has said that if you have been issued a document, it is now for the state to prove that it's issued fraudulently, but that is very often not the rule at national level. Often the substantive law is not clear. I mean, I've been working on this theme now for 15 or 20 years, and I often struggle with understanding what the rules might be. How do you interpret two conflicting provisions? And of course, states don't necessarily follow the law in practice. So just to highlight, therefore, since this is a meeting for judges, the importance of judicial oversight of the executive, because the devil is really in these details around administration that are in the charge of the executive. So judges obviously cannot overrule the legislature. If there are defective laws, there may be a situation in which a constitutional court can say this legislation is not in compliance with the Constitution. But if the Constitution does not respect international minimum standards, for example, then it is for the legislature to overcome that problem. But nonetheless, there are lots of situations in which judges have a role to challenge executive discretion and problematic administration of the law. And in particular, often it is in the implementing decrees or regulations where problems around how do you prove that you are a national are found. And even more significantly, perhaps, in the internal departmental directives, which are often not public, but nonetheless form part of the overall body of public law about how nationality is administered, that you have to get into to find out if a person is a citizen or not, and if indeed the procedures of the executive, of the relevant government department, are following the law. And to highlight here the difference between the civil law and the common law heritage, and I regret to say, as somebody from a common law country myself, and in the context of a meeting largely for common law judges, the civil law system has a lot of advantages. It can be quite heavy administratively, but in particular, it gives a lot stronger role to judges and to courts. So the Nationality Code itself establishes the courts that are responsible for the adjudication of disputes around nationality, and courts at the level of a kind of a senior magistrates court can issue something known as a certificate of nationality. So if you are a person who is applying for a national identity card at the age of 18, and you go along to the office that issues national identity cards and say, you know, my name is such and such, and they say, you know, what's your proof that you are Senegalese, for example? Your last name doesn't sound quite right. You can then go along to the Tribunal Departemental, this is in the context of Senegal, bringing either documents or witnesses and say, look, this is, you know, I've got this, I am a Senegalese, please issue me with a certificate of nationality. The court issues you a certificate of nationality if you fulfill the requirements in the law. You take that certificate back to the office that issues identity cards and say that here, I'm a Senegalese national, issue me with my identity card. And importantly, that certificate is proof of nationality. Only another court, based on new evidence, can overturn that certificate. And this is really important on the burden of proof question. So rather than every application for a national identity card having to be from scratch, you can say, no, look, I've got my certificate of nationality. And although the common law countries sometimes provide for a certificate of nationality, it's usually issued by the minister and therefore inaccessible, and in any event, not really necessarily founded in a due process regime. So the courts have a much stronger role in the civil law systems, where nonetheless the questions of appeal and judicial review are important, but as we know, judicial review is a much more difficult to access because of the requirement to have a lawyer and the expense and so forth. So let's a quick final look at international standards. First of all, around loss and deprivation. First of all, just to note that this is, you know, the right to a nationality and the right not to be arbitrarily deprived of nationality nor denied the right to change nationality goes back to the Universal Declaration of Human Rights of 1948. And the reason why the right to a nationality is in there is because of the absolute centrality of the denationalization of the Jews as the first step to the genocide of the Jews during the Second World War. So a foundational provision in international law. The 1961 Convention on the Reduction of Statelessness has minimum protections against statelessness in relation to children born in the country or born abroad, but also it creates limits to loss and deprivation of nationality as well. And the human rights treaties, including the African Charter on Human and People's Rights, the African Charter on the Rights and Welfare of the Child, establish the right to a nationality, the Convention on the Rights and Welfare of the Child in the case of the African system, but also both of them establish important due process protections, you know, the right to a hearing in case of a dispute. And so to come back to this question about the division between law and procedures, the denial of recognition of nationality in some contexts where the person has in principle appears to be entitled to nationality but is being denied recognition of nationality in practice can in some context count as deprivation of nationality. And in particular, this is the case of people who were previously recognized as nationals, who were told that this was an error. And this is most famously the case in, for example, Kenneth Kaunda of Zambia, who had been president for 27 years and then, you know, stepped down, wanted to run for office again, said, oh no, you're actually Malawian. No, I mean, this is arbitrary deprivation. And people who cannot satisfy evidentiary requirements, even though they are entitled in law and they have no claim to any other nationality. And in this context as well, it may be arbitrary deprivation of nationality. And for more detail on this, look in particular at the UNHCR guidelines on statelessness number 5 on loss and deprivation of nationality, issued in 2020, which, amongst other things, it's another 20-page document or so, state that examples of arbitrary deprivation of nationality include the automatic withdrawal of nationality for an entire ethnic group through a judicial, legal, or administrative action. For example, let's take the Rohingya of Burma, of Myanmar, the withdrawal of a person's nationality without fair trial before a court or independent body, Kenneth Kaunda, and the denial of acquisition of nationality on discriminatory grounds. And this is, of course, many, many people in that context as well. So I shall finish there and leave some time for questions. I recommend to you the website that I maintain, citizenshiprightsafrica.org. But I also recommend the Global CIT, the Global Citizenship Observatory, which is run out of the European University Institute in Italy, which has databases on citizenship law for every country in the world, and with sort of 20 or so modes of acquisition and modes of loss. And you can select for the whole of Africa, for example, and see how your country compares with other countries. Does it provide for the minimum protections for children born in the country who cannot acquire nationality from the parent? Does it allow for automatic loss of nationality for a birth citizen, etc.? You can look at that up in great detail in comparative context and get a sense if your country is an outlier or has much in common with other countries as well. And just a final thing, I have put this, especially the comparative law, together according to the best of my knowledge, but there may be some errors in there, so please don't rely on the slide as fundamental legal advice. Thank you very much.
Thank you, Bronwyn, for an excellent presentation. We have made good time, so we do have time for conversation. So colleagues, feel free to unmute yourself and ask questions. Please, just when you do, introduce yourself and go ahead. So if there are any comments or questions, please go ahead. And
by the way, I still can't start my video.
I'm sorry about that, Bronwyn. Any?
No, Liesl is saying she thinks only panelists can talk.
Oh dear. Joel, can you please unmute? Is it possible to unmute all the participants?
Yes, 1 second.
Or allow them to unmute themselves, otherwise we'll get background noise.
Yes. Liesl, could you try again? Oh, but you are a presenter, so that wouldn't.
Yes, I can unmute myself. The only way at the moment that other participants can engage is by using the question and answer section, so they can type there. Oh, there we go.
All right, just so everybody's admitted into the room, that makes sense.
Colleagues, feel free to raise any questions or comments.
Jakob, can you hear me?
I can hear you, JP. Good morning.
Thank you. Good morning to you. Good morning to the two presenters and to other attendees. I'm sorry for taking this floor, but I couldn't resist thanking both presenters for very well thought out presentations. I must say, in the South African courts, which I monitor closely, statelessness has not featured that prominently, and I wonder what the reason is. Bronwyn, you seem to have looked at our jurisprudence, because I'm aware of the case of the former Angolan refugees who were then required to go back to Angola after the normalization of the situation there. And their children who were born in South Africa were protected in terms of our constitution that they've never been to Angola, they were not born there, they've become South African citizens. So I just wanted to ask you guys, why is it in this litigious environment in South Africa, we've not had that many stateless cases? Jakob, maybe you can also come in here. Thank you very much.
Well, I think that I should hand over to other people in this room, Liesl or in particular. I mean, but just a brief note, just to say, I'm just about to share my screen again, and you can look up the cases that there have been in South Africa. So this is the website that I mentioned that I maintain, and you will see that there are resources here from. Including the resources written by Liesl, indeed, about statelessness in South Africa. But I particularly selected over on the right here. You can select different types of media and different themes: statelessness, acquisition by children, different years. But anyway, I've selected cases and decisions. So here is the recent litigation. I've got 25 cases from South Africa. So there have been quite a lot of cases around acquisition of nationality. Sometimes it's difficult to distinguish the context of statelessness versus the context of acquisition of nationality at all. So, for example, some of these cases relate to children born in South Africa whose parents are refugees. And at 18, in principle, under South African law, they have the right to apply to acquire South African nationality. But in practice, the regulations have not been adopted to allow that to happen. So the law doesn't say that they must prove that they are stateless, although the children of Congolese refugees, for example, they would have trouble asserting Congolese nationality if the correct civil registration procedures have not gone through. But because the regulations have not been adopted to allow people to acquire, they are left without a nationality. And in the meantime, they're born in South Africa, they've grown up in South Africa. South Africa is where their lives are. But this is the litigation that exists, and you can explore it further at your leisure. But I'll hand over to Liesl.
Shall I, Jacob? Oh, okay. Yes, I think a part of it also has to do with there aren't many lawyers who are prepared to take on this subject. We find, I was previously at Lawyers for Human Rights, where we had the Statelessness project, and that's where a lot of these cases came from that project. And we found that many lawyers will just refer cases to us. And now that I'm at the Center for Child Law, where children are involved, they get referred to the Center for Child Law. So many of these cases have been done by Lawyers for Human Rights, Center for Child Law, and some private cases. And also actually the Legal Resources Center, as was the case in the Ali judgment, which I think Justice Mlambo has referred to. And those cases, I suppose, are a bit out of sight, but are incredibly important. What a lot of those cases do is, to an extent, not so groundbreaking, because they merely interpret really what is already in the Citizenship Act. And I think that might seem insignificant, but of course it has a massive impact for the individual involved. But it also has provided us with quite a bit of insight, quite a bit of jurisprudence on how the Citizenship Act should be interpreted. The fact that it should be grounded in the Constitution, in human rights, in particular equality and dignity, and that it is mainly not a migration issue, but an issue about recognizing the genuine links that people in South Africa have to the country that they live in. Some of them may have historically have ancestors who migrated, but most of the affected people are people who have never crossed a border and whose parents have never crossed a border. And so for us, it's mainly an issue of access to nationality, and only once that fails does it become a statelessness issue. So I think that the focus for us should be the preservation of the right to a nationality, which each of us has. And only in the very last case resort, we can afford protection to stateless people. But our first port of call should be to see where the person has a link, and then ensure that they have a nationality in that country.
And if I can jump in just on top of what Liesl said as well, that's the case pretty much everywhere. is that there's a large number of people who don't have an identity document recognizing their nationality. Some of those people will, after exhausting all the remedies available to them, be found to be stateless. No country, after they've gone through all the procedures that they can access, the courts and so forth, will recognize them as a national. But in the meantime, the presumption should be that they have a nationality, and that the litigation is going to start off saying, I have a nationality in South Africa in this context. That's, you're not going to sort of litigate and say, I'm stateless. You're going to say, no, litigate, I have a right to a nationality is where you are going to start. And so that is the case both in litigation, but also more generally. Most of the people who we would say are at risk of statelessness, in that they come from a group that is faces difficulties, which could include the group of vulnerable children. The first step is to say no, they have a nationality, but they have problems accessing it. And the protection as a stateless person is really only a last resort, because in most countries, well, in many countries, the status of stateless person does not exist. And even where it does exist, it often provides you with a rather limited set of rights. You're on mute, Jakob.
Thank you, Liesel and Bronwyn, for those very useful comments, and JP for that question. Any other comments or questions? Okay, if there aren't any, I think we should jump right to Liesel's presentation. If during a presentation you have further questions to ask, again, just note them down in the chat box, or at the end of Liesel's presentation, we will again have an opportunity to ask questions. And as Liesel just pointed out, I did promise at the beginning of the webinar that we will have a 5-minute health break. So it is now 20 minutes to 11 in South Africa. Can we be back in 9 minutes time to 10 minutes to the hour, or 10 minutes to 11 in South Africa? Thank you, everyone. See you back in 10 minutes time. Well, welcome back, everyone. I hope you had time to stretch your legs and prepare yourself for the second interesting part of this webinar. So next up, we have Liesl Miller from the Center for Child Law. Over to you, Liesl.
Good morning. So I'm so glad we had a break, so that I hope we all have made ourselves a mood enhancing snack in between long presentations. Let me just start sharing mine. Slideshow from beginning. Let's see. Oh, I'm sorry. There we go. All right. I hope everybody can see this. I will rely on you to yell at me if you cannot see. I'm so glad that everybody has been unmuted. I have a policy that when I present, I would like people to have the liberty to interrupt me if anything is not clear or if anything is boring, especially. So please do raise a hand or interrupt me. I am going to dive into a bit of the case law, which I'm so glad that Justice Mlambo has raised. A little bit on the continent, but then also locally, I have chosen one or two cases from South Africa and then also one from Kenya. And so that we can look at how these cases manifest in practice. Before we do that, and I'm glad that Bronwyn has brought up some of the comparative issues, I want to just introduce you to what is called the Southern African Nationality Rights Index. So it's an online comparative tool, and it allows you to compare, at the moment, 7 countries in Southern Africa, in terms of law on various different indicators, one of which is loss and deprivation of nationality. Okay, so I can give you, it's done by the Southern African Nationality Network, which you can also find a website for, and then also Lawyers for Human Rights. Okay, so just to give you a very rough overview, this is the results table for the Southern African Nationality Rights Index. Let me just move my things out of the way. There we go. Okay, so you will see that we have evaluated South Africa, Eswatini, Botswana, Tanzania, Zimbabwe, Angola, and Madagascar. And the indicators that we've used range from ratification of instruments, birth registration, many others, but for the purposes of today, loss and deprivation of nationality. And you will see that's number 6 there, that most countries do terribly in the lead on this particular issue, often because of a safeguard against statelessness. Sorry, I think I just need to make an adjustment here. Okay. Generally, in the lead, we have Angola in terms of the laws being in line with international standards and human rights standards. Then we have South Africa, a third Eswatini, then we have Zimbabwe, Madagascar, Tanzania, and last Botswana. So that is where we are at the moment. What the tool allows you to do is to go to each individual indicator and pick an issue and see which exact section in the law is the problematic section. Okay, so let me show you the questions that we've asked in order to give scores to these countries. You will see the first one is the most important one. Does the law make provision for automatic loss of nationality of nationals from birth in any other circumstances than voluntary acquisition? And here you will see that Zimbabwe and Angola, and the results for Eswatini, Botswana, and Tanzania also show that no verification is done on whether the person has another nationality. So it is very likely in those circumstances that a person would become stateless. Then we look at whether dual nationality is allowed and whether it is allowed for children. And then, does the law make provision for deprivation of nationality by decision of government? And then, is there a safeguard against statelessness? Does the law provide that the marriage of a national to a foreigner or a foreigner's divorce from a national results in automatic loss for the spouse or the children? And then lastly, does the law make provision for loss or deprivation for children of a person who has lost or been deprived of nationality? So there you will see that both Zimbabwe and South Africa allow for the automatic loss of nationality for children when a parent is affected. Okay, so that is highly problematic. And Bronwyn has already touched on that. And we can talk about it a little bit more in an upcoming case that I'd like to discuss. But this is just to give you an overview of what's going on in the Southern African region. Of course, we'd like eventually for the whole of Africa to be covered by this tool, but that's of course dependent on resources. The other thing that's interesting about this slide here is that it gives you 6 indicators to show you whether a country's laws is or isn't in line with international human rights standards. Okay, so that's a bit of nitty-gritty, but I wanted to just give you an overview. Okay, sorry, just allow me to connect to a better network here because I see my internet is unstable. Okay, that's much better, thank you. Okay, let me just start off by framing the issue within a human rights context. I think if any of us who were in the last session, we talked a lot about where do we find the right to a nationality, and we talked a lot about the surrounding rights, such as the right to family unity, the right to freedom of movement, the right to dignity. And we looked at quite a bit of the case law, which led to this finding in the African system that the right to a nationality falls within Article 5 of the African Charter. Are you still seeing my screen? Can anybody confirm, Jacob?
Yes, we can. Maybe you can just make it
Yes,
in the presentation format.
Okay. So the African court, relying on various different cases dealt with by the African Commission on Human and People's Rights, have come to the conclusion that the right to a nationality is in fact in the African Charter, and it is in Article 5, which tells us that every individual shall have the right to the respect of the dignity inherent in a human being and to the recognition of his legal status. Okay. So the African Charter puts it in the right to dignity, which I think is correct. And you will see in the jurisprudence that courts have closely linked the right to a nationality to dignity. And as we've discussed before, we've come a long way in terms of how we perceive the right to a nationality, where in the past, it was mainly an issue of state discretion, which falls squarely within the state's reserved domain. And so does not or didn't used to be subject to international law. However, it has developed to a point where it now is no longer within the exclusive jurisdiction of the individual state, and whatever decisions are made in terms of nationality, any laws that are made must comply with or conform to international human rights standards. Okay, so it has come from being something that the state is allowed to decide if a state grants, even just the wording of granting nationality as though it is some kind of a favor that a state does a person. We've come to the point now where it is a fundamental human right, very closely linked to the right to dignity. And that's correct, because I think Tandeka in the next session will talk a bit more about how it affects the individual, but we know that it is a gateway right. That I love because of I'm thinking of the gateway drug. So if you understand that concept, you will know that the gateway works if you have the first one, which is the right to a nationality. You can then access the right to an education, the right to healthcare. And in a country like South Africa, where your nationality is linked to a document that you are required to have on you, or at least easily available, your ID number and your ID document is what stands between you and all your other rights. Even though we know from the jurisprudence that nationality is not so important that we, okay, so this comes from the Chizusi judgment from the Constitutional Court, where the court says nationality is incredibly important. However, we mustn't say that nationality is so important that no other rights can be had if one does not have nationality. So we have to acknowledge that nationality is incredibly important in itself and because of its ability to give you other rights. But we must continue to remember that every human being has the right to other fundamental rights, whether they are citizens or not. So I think that was a very important point that was made by the Constitutional Court. Okay, and then let us just also look at the African Charter. We've previously talked about Article 6, which tells us that every child has the right to a name and a nationality from birth. The same is said by the UN Convention on the Rights of the Child. But what I want to point out here is the second, or Article 4, subsection 2, which tells us that in all judicial or administrative proceedings affecting a child who is capable of communicating his or her own views, an opportunity shall be provided for the views of the child to be heard, either directly or through an impartial representative as a party to the proceedings. And those views shall be taken into consideration by the relevant authority in accordance with the provisions of appropriate law. Okay. I wanted to put this out there immediately for us to keep in mind. We often forget that when we deal with children, or in cases where children are affected, and I would argue that in almost all cases, children are to some degree affected, there is a procedural requirement in terms of which judges are required to take into account the views of children. And so there's a lot there to be said about how does a judge do that. Ideally, the parties would already provide the court with the views of the child. And when the judge makes a finding that the judgment must show that the views of the child was taken into account, how it was taken into account, and what the decision is that was made. And I want to put this out there immediately just because when we litigate, we pay appropriate attention to adults and we take instructions from them. We do not act without their instruction, but we often don't do the same for children. And as we know, children are also people too, and citizens. I say jokingly, but a lot of people don't understand that concept that a child is a citizen also, and sometimes a non-citizen who is also a resident in a country with the same rights. Okay, we'll talk a bit more about that in a bit. So I want us to start here at this judgment from the African Court. So the judgment is about an individual called Anudo, and it was against the Republic of Tanzania. So Tanzania is one of, I think, 5 countries who have made the declaration that allows the African cases to be brought against it in the African Court. Of course, this court is what we are trying to empower if we indeed want to prosecute in our own continent instead of being prosecuted by under the Rome Statute. So, of course, we have more work to do in terms of empowering and this court. But leaving that aside, you will see that the two cases that I mentioned here are against Tanzania. And so that's, of course, not ideal, and we'd like to see a more varied jurisprudence, but this is where we are at the moment. Interestingly, the first case at the African Court and at the African Committee on the Rights and Welfare of the Child are about nationality. So it is fascinating that these issues are kind of on the periphery, but they are clearly issues that are largely unsolved at a domestic level or at a level before it comes to a court. So it is and has been incredibly important for individuals to have judicial oversight of nationality decisions and administration. Okay, so we are talking today about loss and deprivation. Now, a very common argument that comes up in these cases is that a decision maker will say, well, I've never taken away your nationality, so I've never actually deprived you of a nationality. I've kind of just not made a decision yet. And that the court in this case finds that is arbitrary denial. So this kind of situation where we require individuals to come forward with proof, and as soon as they bring one piece of evidence, we say, bring another, okay, no, bring that one. And this kind of can go on for many years in cases that I've dealt with over 10 years in the legal clinic at Lawyers for Human Rights. This is the main issue, that individuals are just not able to meet the standard of proof. Okay, so that is arbitrary denial. And in the case of Anudo, he was deprived, so he'd been treated as a national his entire life, and then came up in politics. And as soon as he started making waves, the state then deprives him of his nationality and very conveniently deports him to Kenya, where a Kenyan court finds that he's not Kenyan, and he is deported back to Tanzania, and a little bit of a ping pong game there with an actual human being. And this is why when we say that nationality discretion is not something that can be left to the wide discretion of an individual decision maker, that this is the context within which we can understand that it's incredibly important. The same thing happened to the very first case, which came to the commission, the African Commission, which was called Modise versus Botswana. And in this case as well, a political situation, a person suddenly deprived of their nationality, again, using at that point later in a person's life, saying, well, you never had nationality. Now, at this point, you must prove it. Okay, so that goes a bit into where the burden of proof should lie. And I do think that we need a bit more jurisprudence on that, but there is certainly a bit of emergence on that that we can also look at. Okay, but what the court in Anudo says, which is incredibly important, is that arbitrary deprivation is not only a positive action. So where a decision maker says, okay, you have nationality, and now I'm taking a decision to deprive you. Okay, so that's a positive action. It doesn't end there, but arbitrary denial. So the situation where we constantly reject your application to be recognized also falls within arbitrary deprivation. And that's incredibly important for Africa. And I think that these kind of cases will become before courts where judges in this room will sit. And so in the African court, the judges are allowed or have the jurisdiction to consider any treaty to which the country is party. And so in this case, the court ventures beyond the African Charter to also the International Covenant on Civil and Political Rights, and relies on Article 14, the right to a fair hearing, and also the Universal Declaration of Human Rights, Article 15, which tells us that every person has the right to a nationality. Okay, then in the next case, which comes before the African Court, which is Penesis versus Tanzania, the court relies then on ANUDO and also on the Universal Declaration of Human Rights, and says that the Universal Declaration of Human Rights is indeed customary international law, which most of us already had that opinion, but it is good for us in our African system to recognize that Article 15, which gives every person the right to a nationality, is in fact a binding norm and is part of customary international law, and is something then, of course, that a court can rely on. And also part of Article 15, no one shall be arbitrarily deprived of his or her nationality. And so, yes, just as an interest, the damages awarded to Penesis in this case is 10 million Tanzanian shillings in moral damage and 300,000 Tanzanian shillings for every month that he remains in detention until he is released. Last time I checked, this man still did not have his Tanzanian citizenship back. So this is one of those sad situations where we got good jurisprudence, but the individual was actually not any better off. So yeah, but we continue to follow that and to see what can be done there. Okay, so these two cases in the continental law, regional law, tells us that there is a right to a nationality, and that the arbitrary deprivation is a violation of that right, and that arbitrary denial is also arbitrary deprivation. Okay, just to settle those issues. Let me maybe, I want to just read you a quote. I think what is interesting about these cases is that courts are very reluctant to interfere with citizenship matters. And this is also an argument often made by the respondents in these cases, which in the context of South Africa is the Department of Home Affairs, will say that this is a case of separation of powers. And of course, that is a serious argument. But what the court in Njuguna, in this case, Njuguna versus the Department of Home Affairs, the Constitutional Court tells us actually, citizenship is not a matter of discretion. It is a matter of interpretation of the law. And therefore, it is not a judicial overreach, and the separation of powers remain intact. There is, of course, a difference between citizenship by birth. In the case of South Africa, you have, well, let me say, every country will have a different citizenship law, and certain forms of citizenship will be automatic and discretion will be out of the question. And that is normally the case with citizenship by birth. For instance, in the South African Citizenship Act, the law says a person who is born to a South African citizen, or to a person who is a South African citizen on the day of their birth, shall be a South African citizen by birth. Okay, so there's no discretion involved. That is something that happens ex lege. So the Citizenship Act is the act that grants or kickstarts the right. The law is where the right vests. So the court, in fact, does not decide or grant. The court merely interprets what the law says and declares a right. Okay. However, there are cases such as in naturalization. Okay, so naturalization is where a person already has another nationality, hopefully, and then their situation changes in the sense that, let's say, they move to another country because of a partner and lives in that country, married to a national of that country for X amount of years. Now, this person has established new links to a new country, and the country where they now reside has a discretion to grant nationality to a person like that. So in a case like that, the court will not be in the same position to be able to substitute the decision of the minister. Of course, then the normal rules apply, the normal rules of judicial review. Maybe let's just look at that. Sorry for skipping around in my slides. Okay. We know that in most of our countries, we have judicial review based in the common and civil law. We also have administrative justice legislation. So either your country's law, common or civil law, already allows for judicial review of administrative decisions, or like in South Africa, the Promotion of Administrative Justice Act. That act specifically makes provision for judicial review. And then, of course, there is also what we call special statutory review. Now, of course, I'm telling you things that you, of course, know, but I want to just place what I'm going to show you within the bigger picture. So, for example, the South African Citizenship Act contains a provision which, in addition to the Promotion of Administrative Justice Act and the Constitution, gives the court specific jurisdiction. So it says, any provincial or local decision of the High Court shall have jurisdiction to review any decision made by the minister under this act. A court hearing a review in terms of subsection 1 may call upon the minister to furnish reasons and to submit such information as the court deems fit. And the court shall have jurisdiction to consider the merits of the matter under review and to confirm, vary, or set aside the decision of the minister. So if there was any doubt still as to whether it is a separation of powers issue, this subsection gives a special statutory review power to the court. And if there was doubt whether the court is in a position to consider the merits, this also settles. Okay, so this is ideal. It's not the case in many countries where you may be based. But like I said, you can also come to the same conclusion by interpreting the Citizenship Act. Okay, where are we? Let me just check our time. Okay, we still have a little bit of time. Let me go back to the South African jurisprudence. Okay, so in the early days, even before Chuzusi, and when I just started at IARMJ in 2013, the very first case that came across my desk was the case of what we called a blocked ID. Now, if you are in South Africa and you've been following, it's been very controversial. A few weeks ago, a case was in court in terms of which this ID blocking practice was challenged. So let me just explain how this works. So this client of mine, Mr. Nzama, and at the time when I left IARMJ, 50 other clients, and at this moment, 130 affected people that we know of, they live their whole lives as South African, and at some point, when trying to renew their driver's license or access a bank account, they are told that they're an illegal foreigner and that their ID number is blocked and that they must approach the Department of Home Affairs. So each one of these clients, that 130 clients that we have assisted so far, then approached the Department of Home Affairs, where the local office will tell them, they can even sometimes print out a little screen grab of the feedback system for the National Population Register, which says illegal foreigner, and that's the extent of the information. And they are then told that the local office don't know what to do and that they must approach the head office. Some other offices are very willing to assist, but no matter how much evidence they send to the head office, nothing happens of it. Okay, so fast forward then to 10 years later, this matter, not this one, sorry, another matter called Mazibuko, which was in the news recently, comes to court, alleging that this process is unconstitutional. Okay, but before that, Nzama, which was one of my early clients, the court says that minister's failure to determine a person's citizenship is in violation of the Constitution. So again, it reminds us of the Anudo judgment. This failure to make a decision violates the person's right to a nationality. And I've put this here to remember, to tell you that Section 20 of the South African Constitution says that no citizen may be deprived of citizenship. Okay. In this case, the High Court interprets the Citizenship Act, finds that he qualifies, declares him to be a citizen, and orders the Department of Home Affairs to unblock his ID. Let us fast forward to Mazibuko. Now, don't start reading these letters. I will tell you about them in a second. Mazibuko is a woman who is actually a permanent resident. So you may know that in South Africa, citizens as well as permanent residents have ID numbers because both of their details reflect on the National Population Register. So it was in approximately 2015 when the department had a kind of upgrade and they were able to computerize a lot of their records. And what this meant is that the whole population register is now on a database which is linked to other immigration and other systems. Okay, that means that any immigration officer anywhere in the country can make a decision about whether they suppose, on their basis of their own discretion, whether there is something dodgy about the citizenship of a person, can alert the head office, at which point a kind of flagging block will be placed on the ID number, which will immediately stop the working of that ID number, and the person will not be able to access their bank account, register their child to their child's birth, have their death registered, any kind of these things. Okay, and what we find then is that there's no process to resolve this case, and that in some cases up to 12 years of no resolution, even when lawyers are involved. The cases that I was able to resolve was when, I think by pure luck and perseverance, because we would put together a docket of every kind of evidence that you can think of to show that the person is a citizen, send it off to the head office and get no response. And in one or two, I don't know how many cases I was able to resolve, but by the time I left, like I said, there were still 50 unresolved cases and now 130. Okay, so in Mazibuko, the applicant, who is a permanent resident, also found that her ID was blocked. What the department was able to tell her is that there is another person with her same ID number and that she is the one who committed the fraud. But as it turned out, and spoiler alert, her ID has since been unblocked because indeed she is not the one who committed the fraud. So what the department did there is to find something dodgy, which is, okay, two people have the same ID number. Yes, that indeed is dodgy. The only action taken by the department is to block the ID and then to say that we will now investigate. What comes out in the court papers is that no investigation was done. The ID just remained blocked. And of course, the person who bought her ID number or somehow fraudulently acquired it is punished. Yes, they have no ID number anymore, but at the same time, Mrs. Mazibuko, who is legitimately the holder of that ID number, is also in limbo. Okay, so the applicants bring this case saying that there is firstly no legislative provision which allows the department to make this decision. So in South African law, such an administrative decision can only be taken if there is a law which allows the decision maker to make that decision. So first, that was the first argument. And then, of course, there was a lot of argument about how it infringes on the rights of these individuals. And the court was asked to judicially review this decision and the policy as a whole, and then to unblock all IDs because the procedure was not followed and because the administrative action is unlawful. What we did is we came in as an amicus to support that relief. We, as the Center for Child Law, represented the Children's Institute, and we brought the case of 6 families to the court. And what we did is we provided the court with evidence that the children of people with blocked IDs are not being registered at birth as a direct result. And where children are already registered and before the ID is blocked, that child's ID also becomes blocked. And what then happens is that these children are not able to attend school, and very importantly for the children in this case, which are resident in the Eastern Cape, they cannot access a social grant and suffer severe malnutrition. In the case of these 2 children, their mother has passed away and they live with a grandmother who no longer works. Okay. So what we did here is we follow what is called a child's rights compliant approach to strategic litigation, which you can read up more about at that website link there. And it's based on the very principle of child participation, which I mentioned before, which is about the child's right to participate in matters to which they in which they are affected. Okay, so like I said before, it's a rule of procedure, but it is also a substantive right. And what the African Charter and the South African Constitution and the Children's Act say is that when you as a court or a lawyer or an attorney representing a child decide what the best interest of the child is, you can only really do so by hearing the child's voice. Okay. So the rules of determining the best interest include hearing the child's voice. So your inquiry must include the child's participation. So if you haven't done that, you really actually can't come to a conclusion on the best interest of the child. That, of course, doesn't mean that the child will tell you what his best interests are, but when you decide it, you will take various things into account, one of which is what the child thinks and feels. And so in order to really properly comply with that procedural rule, we not only allow parents to depose to affidavit, but in this case, we ask the children to write to the court themselves. And not only, that, oh, I'm sad I don't have an ID, but we also ask them, what do you want the court to do strategically, or not strategically, systemically? Like, do you want the court to think about other children who are in the same position? And if you do, what do you want the court to know about that? What do you want the court to do? So we don't only ask the children to tell us whether they're sad or not, which is also very paternalistic, but we ask them as individual agents of change and litigants that what is it that they are interested in? Okay, so let me just read you a little excerpt from their letters. All my friends were going to school and were enjoying their grant. At the time, I had no grant. I remember when I was grade 5 at Ndlovini Primary School, many learners were getting school uniforms, and I was the one who couldn't have it And I felt very sad. So this child was able to go to the primary school for a little while before she was no longer allowed. I applied for my birth certificate this year at Home Affairs, and I was very happy to apply for it. When I went back, I was not able to get the birth certificate because the manager was not at the office. I want the court to tell the minister to give us our birth certificates, because children like myself without birth certificates struggle to go to school and also to get social grants without birth certificates. And both of these letters are like 3 pages long, and it reveals various different things about the personal circumstances of a child, and it will enlighten judges as to what kind of remedy will be effective. And so I want to highlight this as a very important part of determining whether action will be taken or not taken. So I want to just also then draw your attention to another case within South African law, which is the case of a school called Pridwin. The parents of these children were taking action against the school. The children were expelled because of action or because of the behavior of the parents. And the court considers the fact that the school is a private school, and that whether the school has a duty to adhere to the Bill of Rights when it takes decisions which are or seem to be contractual. So does the school which has a contract with the parents, do they have a duty to the children? Now, we know that the Constitution also applies horizontally, but what the school was arguing here is that it is a purely contractual matter and the children have nothing to do with it. And I mean, I'm simplifying the arguments, of course, but it's a very good judgment to read for this purpose. But the court then finds that regardless of the fact that this is a private matter and that it is a contractual matter between the parties, the fact that the school did not consult with the children before expelling them is what is a violation of the Constitution. And yes, it's a contractual matter, but the children are affected to such a massive extent that not allowing them to participate and taking into account their best interests and taking into account their views is a violation of the child's right to have their best interests considered paramount in matters that affect them. And it's a wonderful judgment to read by the Constitutional Court. And it reminds us that not only where the state is involved, but even between individual parties, we have to consider the best interests of the child. Okay, so that is at the extreme end. But what we argued in Mazibuko is that the department's actions in terms of blocking IDs are reviewable based only on the fact that they never considered the best interest of the child and allowed them to participate. And by that, we also mean that the child's case was not individually assessed. So we do what the Constitutional Court nearly 20 years ago guarded against when in S versus M, when it tells us that the child is not just an extension of a parent, like a limb, an arm or a leg, that if the parent is affected, the child just kind of follows and we visit the sins of the fathers on the children. We're not there. What the court in that case is that children are individual humans. So I was joking about that, but that is what the court says. Can we please treat children as individuals? And so this is the argument we made in Mazibuko, that even in the decision whether to block an adult's ID, one has to take into account how that affects the child. And the fact that the department didn't, it makes the decision to block the parent's ID unlawful. Okay, but there are also various other reasons why that decision is unlawful. And one of them is the fact that the child is being deprived of their nationality. And so we're still waiting for judgment on this matter. It's at the High Court level at the moment. Let me just check my time. I feel like maybe now is a good time to see if we have questions. Oh, let me read you this quote from the Constitutional Court. Citizenship and equality of citizenship is therefore a matter of considerable importance in South Africa, particularly bearing in mind the abhorrent history of citizenship deprivation suffered by many in South Africa over the last 100 and more years. Citizenship is not just a legal status. It goes to the core of a person's identity, their sense of belonging in a community, and where xenophobia is a lived reality, to their security of person. Deprivation of or interference with a person's citizenship status affects their private life and family life, their choices as to where they can call home, start jobs, enroll in schools, and form part of a community, as well as their ability to fully participate in the political sphere and exercise freedom of movement. Okay, so the court really impresses upon us how incredibly important it is, and the fact that the apartheid struggle was a struggle for citizenship. And if you look into it, I mean, the apartheid project was largely about deprivation of citizenship, wasn't it? And by putting people in specific areas and trying to give them their own nationality and denying that they are South African citizens. So it's an incredible political tool. It's an incredibly powerful political tool. And the courts are really the last bastion against that kind of very wide discretion that the state still has. And what I would argue is completely a violation of international and most domestic laws. But what we see is that in practice, states are still very easily, very freely making, I'm sorry, but willy-nilly decisions about people's nationalities. And these cases are coming before the courts because, of course, you are not going to the state to resolve that. It is the state, indeed, that is depriving you of your nationality. So what we need to do in law, I believe, my opinion, is that yes, Parliament must take a very strict stance when it legislates in terms of what are due processes, are reasons given in writing, is there an administrative appeal? Does the person have to go to a court immediately? Because as we know, that's a very long and a very involved and a very expensive process. But we don't all have those processes at the moment. I can show you in our index, here number 7, due process in nationality decisions. Probably one of the worst categories in terms of how badly countries do. Most of these countries do not provide for an administrative appeal, including South Africa. And most of them do not provide for the right to be given reasons unless it is in a very general law, such as the Protection of Administrative Justice Act. In South Africa, there's no practical implementation of the Administrative Justice Act in home affairs decisions, which is shocking and incredibly endangering of human rights. Some of these countries, Tanzania, for instance, have a provision which says that the court specifically does not have jurisdiction to review the minister's decision, which is an incredible thing if you think about the massive impact that it has on the rights of the person, of the individual affected. Okay, so we're in a place, and let me, oh my goodness, I've definitely taken more time than I need, but let me end with saying that the court's role here cannot be overstated at this point. We need the courts to uphold the rights of these individuals and to tell us what are the perimeters, what are the rights of children and adults in terms of due process, when is loss and deprivation constitutional or not. So I think that the duty and the responsibility that falls on the courts at this point is really something to think about, not necessarily because you've chosen it, but because these are the cases that we are bringing to the courts at the moment. Okay, so that's what I'd like to end with, and I just want to leave you with some resources. There is also this is the website that Bronwyn was talking about. Then there's also the Southern African Nationality Network's website where you can find the index. And then there's also a very large database online in the Institute for Statelessness and Inclusion, which has a new report on citizenship stripping. And there's a lot out there, and I will also send you my slides. Thank you.
Thank you very much, Liesl. And maybe just to add to that list of resources, on the website of the International Association for Refugee and Migration Judges, there is also a link to the African Lee case law database, and where you could also do searches for case law as well as the applicable legal instruments. So please also consider that. Right, it is now almost 1:45, so I think we should give our last speaker, Thandeka Chauke, an opportunity to give her presentation. Over to you, Thandeka.
Thank you, Jacob, and good afternoon to everyone. I will just need to share my presentation. Okay, so how do we maximize this? Okay, hopefully everyone can see my screen. I have been in and out of this discussion, and I do think there might be some overlaps between my presentation and the people that have gone before me, but I will try to keep it relevant to maybe issues that have not been discussed as yet. And please don't mind the video camera. I think it's doing something strange, but yes, we'll get through the presentation. My name is Thandeka Chauke, and I am the Statelessness Project Manager at Lawyers for Human Rights, and also the administrator of the Southern African Nationality Rights Network. This quotation is relevant to the discussion, and I'm happy that Liesl has already raised it. It's a quote by Justice Kampepe in the Constitutional Court judgment of Chisuse versus the Minister of Home Affairs in the South African Constitutional Court. My presentation is based on a forthcoming paper that looks at challenging covert citizenship stripping practices and safeguarding the right to nationality in South Africa. And basically it explores the intricate dynamics of citizenship stripping and citizenship rights within the South African context, looking specifically at the history of citizenship in South Africa and how it has been something that is historically controversial, deeply intertwined with the struggle against colonialism and apartheid, which is something that is reflected in this quotation. South Africa's transition from apartheid to democracy in '94 obviously then marked a significant shift towards equal citizenship and human rights for all, and that is now reflected in Section 3 of the Constitution, which provides or recognizes for a common South African citizenship, and Section 20 of the Constitution, which is an important provision against arbitrary deprivation of citizenship. However, what we see is that the issues of citizenship and citizenship stripping remain a contentious issue even today. I hope Liesl has mentioned this case, but it is the Democratic Alliance versus the Minister of Home Affairs case, another recent case that looked at a specific provision of the Citizenship Act that was resulting in the deprivation or withdrawal of citizenship automatically for South Africans that were acquiring citizenship of foreign countries through naturalization. And then, of course, Mazibuko, which is a matter that Liesl has also just discussed, where Lawyers for Human Rights is one of the applicants in this matter. Legal Wise is the third applicant. and the Children's Institute is an amicus curiae represented by the Center for Child Law. And what Mazibuko looks at is another covert practice that the Lawyers for Human Rights has since picked up, which is the issue of ID blocking. And what we see from these two cases is how, even today, issues around ID blocking and citizenship stripping remain relevant and require our sustained vigilance in terms of safeguarding the right to citizenship in South Africa. The practice of ID blocking, this is just to trace where it kind of originated or where the Lawyers for Human Rights picked up this practice back in 2012, when the Department of Home Affairs had initiated a campaign to clean up the National Population Register, so to speak, when they realized that it had been contaminated by duplicated or multiple ID numbers. Obviously, over the years, this problem only got worse and worse, with more than 2.5 million people eventually ending up with their IDs being blocked on the National Population Register. The Department of Home Affairs has stated that they use ID blocking as an administrative tool to maintain the accuracy and integrity of the National Population Register. When they block the ID, they're referring to a marker that is placed against an ID number, indicated that it is tainted by either an administrative or clerical error or linked to cases of suspected fraud or misrepresentation. LHR in the last 5 years alone has seen over 500 people with the problem of blocked IDs and tried to assist them in unblocking the ID. The demographic is also important as a reflection on the historical context of citizenship stripping in South Africa. Majority of the cases we have seen are of marginalized Black South Africans. So it's that same demographic that was targeted during apartheid and the same demographic that was stripped of their citizenship when we had the TBVC homelands. Some of the cases that we have seen involve people who are in fact, or majority of the cases, people who are in fact legitimately South African citizens. In this one case of SB, he was born in South Africa in 1972 to a South African mother and a Zimbabwean father. He discovered his ID was blocked in 2018 when he tried to register his child's birth at the Department of Home Affairs. His sister had encountered a similar issue in 2008 while opening a bank account, and his brother had encountered the same problem in 2020 while replacing a lost ID. Though all three were South African born, they had briefly lived in Zimbabwe with their father before returning to South Africa in the early 90s. SB recalls being detained and questioned at the border during that time until their mother came to collect them. And in the absence of any explanation from the department, he can only guess that this may be linked to the blocked ID. In order to prove their citizenship, they submitted all their birth records, school records, their mother's documents, and attended numerous interviews. In 2021, they were instructed to do a DNA test with their mother, which they did at their own cost, but tragically, their IDs remained blocked until last week. So their lives had been thrust into limbo, unable to access bank accounts, maintain jobs, and support their families. And so this is one example of the 134 case studies that we placed before the court in Mazibuko in order to demonstrate issues related to ID blocking and how they impact people on a daily basis. This is a quote from one of the emails I'd received from SB at the time that he reached out for help, saying, "We are so desperate, frustrated, and broken due to the problems caused by Home Affairs. Our lives are at a standstill. We can't do anything, no ID, no life." In all the cases, we noticed that this act of blocking the IDs was essentially unilateral. So none of them were aware their IDs blocked until they try and use that ID for some other service or reason. None of them are given written notice, no written decisions, no opportunity to make representation. So the fair trial requirements were also violated, and no written decision or administrative appeal or review. So it's the same kind of trend that would have been demonstrated even in the cases that Liesl has demonstrated. And then linked to this issue of blocking the ID is, of course, all the other constitutional and human rights that would be implicated. One of those being the right to citizenship. In a lot of the cases, the ID would be blocked, and the reason the person is given is because either they suspect that you are an illegal foreigner, quote unquote, or that you have been traced to some other foreign country. So that declaration of them saying, we no longer recognize you as a South African citizen, and we think you're a citizen of X country. When that person approaches X country, they would say, we don't recognize you as a citizen of this country either, therefore rendering the person stateless. The right to just administrative action, I think it's a clear violation of all those provisions that we have in our administrative laws, and the right to a fair hearing as it is encompassed in international human rights law. The right to human dignity and further deprivations. So even from the quotes provided by SB, you would see not only the human rights implications, but the psychosocial impact it has on people whose IDs have been blocked and stripped of their identity and citizenship. With the blocked ID, an invalidated ID, you cannot access anything else that requires you to produce an ID, whether it's registering to vote, applying for a birth certificate for your child, getting married, applying for a home loan. All of those services and other essential human rights are inaccessible to a person with a blocked ID. And then, of course, the rights of children and the risk of childhood statelessness, as demonstrated by the cases that Liesl has presented, showing the derivative impact of a blocked ID. So now we'll look at what the international human rights laws and standards provide, right? So if we look at the 1961 Convention on the Reduction of Statelessness, it has particular provisions that speak to loss, renunciation, and deprivation of nationality. Obviously recognizing that states do have the sovereignty to craft and come up with their own laws as to how people are given citizenship, how they lose citizenship, and how that citizenship can be withdrawn. But of course, there is that qualification to say that these laws must still be in alignment with what international human rights law says. And even when we look at the provisions of the 1961 Convention, we see that they are important safeguards that states should put in place if they intend to deprive a person of nationality in order to prevent that person is then rendered stateless through the deprivation. Some of those safeguards are that deprivation of citizenship can only be lawful if it is prescribed by law. So if it is not prescribed by any law, that's an indication that it is arbitrary deprivation of citizenship. And this is what we were seeing in the ID blocking, is that it was deprivation of citizenship happening through practice and not through the application of any general law in South Africa. There's also the requirement of proportionality. So it must be the least intrusive means proportionate to achieving a legitimate aim. And the legitimate aim in ID blocking, as put forward by the Department of Home Affairs, is the need to maintain an accurate national population register. That is a legitimate aim. But the manner in which they were doing it was not proportionate to what they intended to do, especially because it was not prescribed by law and they were not following the actual provisions in law that deal with cases of suspected misrepresentation or fraud in acquiring identity documents. In the absence of a proper, transparent process to block an ID and to remove the block, we are also seeing cases dating back as far as 2004 that remain unresolved to date. So that person's ID has been blocked since 2004. They've been locked out of many opportunities, been deprived of several of their rights and entitlements for the past 2 decades, and that cannot be proportionate to the aim of maintaining the National Population Register. It takes place without due process. This is also an indication that the deprivation is arbitrary. Due process requirements, as we know, are that you must have notice, you must have requirements for fair trial, the ability to make representations, to be legally represented. It must deal with issues of burden of proof, which have also been established in the African court. If you look at the decision of Anudo, that says that the burden of proof in cases where you have been deprived of nationality rests on the state that is depriving the nationality. So the indication of a person who holds an ID is that you are entitled to that ID. But if the Department of Home Affairs says otherwise, they have the duty to prove. But what we had been seeing with ID blocking is that the person's ID would be blocked and they would have to go and run investigations by themselves to prove that they were indeed entitled to the ID in question. Other questions it raises, and which might be explored in the judgment, is the issue of effective remedy. What do we do then in cases of wrongful deprivation? should we be considering damages in those cases? In the cases that Lawyers for Human Rights has managed to resolve in the absence of litigation, where it had turned out that the person had been wrongfully traced as a foreign national, the ID simply unblocked and the person is expected to continue with their life. But these are people who might have already lost their job or job opportunities or other implications for their lives. And how do we compensate them for that loss related to the wrongful deprivation? The international guidelines that have been produced by UNHCR and also contained in the principles on deprivation of nationality also speak to issues of deprivation in absentia, because one of the issues that the Department of Home Affairs has raised in the past is that we block the IDs because we do not know where to find these people. So we don't have the means through which we can contact them to notify them that we have seen an issue in the National Population Register with their ID. And the guidelines provide for alternatives to this. How do we deprive someone in absentia in those instances? Can we seek a court endorsement? And if the person does present themselves again, should we begin the process afresh ab initio once the person has discovered the deprivation? And I think these are important guidelines to be considered even in the adjudication of matters dealing with deprivation of citizenship. Definition of citizenship stripping or deprivation of citizenship is also provided in the guidelines and the principles. It refers to any loss, withdrawal, or denial of citizenship that was not voluntarily requested by the individual. The principles further state that deprivation of nationality also covers situations where there is no formal act by a state, but where the practice of its competent authorities demonstrates that they have ceased to consider a person as a national, including where authorities persistently refuse to issue or renew documents, or in cases of confiscation of identity documents, coupled with a statement by authorities that a person is not considered a national. And when we look at all the case studies, the 134 case studies before the court in the Mazibuko case, you will see that majority of them meet this definition of citizenship stripping. So what are some of the minimum standards that have been prescribed in guidelines and principles? The avoidance of statelessness is one of those when we're looking at the citizenship stripping powers of the state. So we must make sure that states must not render any person stateless through deprivation of nationality, and the burden of proof in determining that the person concerned holds another nationality must lie with the competent authorities of the depriving state. Number two, the prohibition of discrimination, which is also contained in the 1961 Convention on the Reduction of Statelessness, that no deprivation can be permitted if it is based on a discriminatory factor. So this includes race, color, sex, language, religion, political or other opinion, national or social origin, disability, sexual orientation, etc., all the grounds of discrimination. Prohibition of arbitrary deprivation of nationality. So no deprivation of nationality should be permitted if it is arbitrary. So this is looking once again at procedural safeguards, the right to fair trial, effective remedy, and reparation. In any proceedings concerning the deprivation of nationality, the right to equal access to justice and equal treatment before the law must be enforced. And this is all important in terms of adjudicating cases that might concern the deprivation of nationality or citizenship stripping. In terms of recommendations and guidelines to respond to some of these challenges that we're seeing in safeguarding the right to citizenship in South Africa, ultimately, we're arguing that while states are entitled to determine who their nationals are under their own laws, these laws must adhere to the obligations and principles that are established in international human rights law. Those four principles: the avoidance of statelessness, the prohibition of discrimination, the prohibition of arbitrary deprivation of nationality, and ensuring the right to fair trial, because these then provide a robust framework against arbitrary deprivation of citizenship and promote the safeguarding of nationality rights. What we've also recommended or continue to advocate for is for nationality determination and statelessness determination processes within African states to ensure that citizenship stripping powers take into account whether or not an accurate determination of a person's nationality has been made before they're deprived of nationality on the basis of being suspected to be a foreign national. And that a statelessness determination has also taken place to ensure that the person who's deprived of nationality does not become stateless under the 1954 Convention. Due process, an important tool for to keep states accountable for excessive discretion in nationality administration. This case of Mazibuko is a timely reminder of the fact that in the face of unchecked authority, we need to sustain vigilance in curbing arbitrary deprivation of nationality and challenging problematic citizenship stripping practices that we see across the continent. It is also a great consideration of the adoption and ratification of the draft protocol to the African Charter on the specific aspects of the right to nationality and statelessness in Africa, as it provides a lot of provisions that are relevant to the context of Africa, where a lot of people struggle in terms of proof of nationality, and also help us to challenge what we consider as an appropriate connection or link to a country. And I think I will end there. And yeah, maybe we can open up for discussion. I hope I have not repeated too much of what has already gone before me, and that this has been a helpful presentation. I will share the slides with the organizers so that they can contribute them. Thank you very much.
Thank you very much, Thandeka. And yes, I think we have a few minutes for questions and comments to both your and Liesel's presentation. So if there are any questions, please go ahead. Well, if there aren't any questions, it gives me great pleasure to thank all our speakers, Thandeka Chauke, Liesel Miller, Dr. Bronwyn Manby, and Ivy Njuguna for your excellent presentations. We will make available the presentations, and please also just to make you aware of the final training program this year. This is a online training program on which is an introduction to international refugee law and practice, and which will be hosted in the first week of December. It's a 5-day course presented by fellow judges from our region, UNHCR colleagues, and experts on refugee law from our region. So please be in contact if you need more information, and so that we could make sure that you get registered. Again, thank you to the UNHCR for making this webinar possible through their financial assistance to the International Association for Refugee and Migration Judges and the Judicial Institute for Africa. Thank you, everyone, and I hope you have a very good weekend, and until we see each other again, goodbye.
Thank you, Jakob. Bye, everybody.